Supreme Court has just issued a ruling involving hundreds of people convicted for their actions under a 2002 financial crimes law applying to evidence tampering.
This is a potential win for this defendant from the Capitol on January 6th and was charged with this obstruction of an official proceeding.
Justices weighing whether to reverse the convictions of hundreds of January 6 rioters charged with obstruction. The case brought by Joseph Fisher, who entered the Capitol on January 6 and was charged with obstruction.
In a significant decision on Friday, the U.S. Supreme Court ruled that federal prosecutors had misapplied a law in the case of a man involved in the January 6, 2021 attack on the U.S. Capitol. This ruling immediately impacted some of the 249 individuals convicted of obstructing an official proceeding. Shortly after the decision, a federal judge ordered the resentencing of one man convicted under that charge. The case involved Joseph Fisher, who was charged with obstructing the congressional certification of President Joe Biden's victory using a law originally intended for cases like the Enron scandal aftermath. Fisher, although not entering the Capitol during the riot, was seen in video footage encouraging the crowd and leading rioters upstairs outside the building. This development marks a pivotal moment in the legal aftermath of the Capitol assault, a case that has drawn considerable attention, including from former President Donald Trump, who also faces similar charges related to the events of that day. Here's a breakdown of the latest from the Supreme Court, hot off the press. Chevron doctrine overturned. The Supreme Court made waves by overturning its own 1984 Chevron decision. This ruling has historically allowed courts to defer to government experts' interpretations of ambiguous laws. The 6-3 decision marks a significant shift in federal agency regulatory powers, reflecting a conservative majority stance. Implications for January 6 Capitol attack cases. In a 6-3 decision, the court narrowed the statute used in prosecutions related to the January 6 Capitol attack. This ruling could drastically impact the cases of rioters involved and potentially influence federal charges against Donald Trump. Special counsel Jack Smith's investigation into the assault is closely tied to these developments. Criminalization of unhoused people. In another 6-3 ruling, the court upheld Grants Pass, Oregon's ordinances criminalizing unhoused people sleeping outside even without access to shelter. This decision underscores a victory for local authority over homelessness policies in the western U.S. Upcoming decisions. Stay tuned for Monday's final opinions, including the court's decision on Donald Trump's claim of absolute immunity. Several key cases remain pending, including Trump's challenge to immunity from prosecution related to his actions after the 2020 election. Recent highlights. Earlier this week, the court allowed emergency abortions in Idaho temporarily. It also rejected Purdue Pharma's bankruptcy settlement, limited the SEC's powers against securities fraud, and paused the EPA's efforts to curb cross-state air pollution. And now that you're updated with recent court proceedings, let's now delve into the implications of the January 6 riots decision and what it means for ongoing legal battles and precedents. January 6 ruling. The Supreme Court concluded its opinions for Friday with a series of landmark decisions. In a pivotal ruling, the court determined that federal prosecutors had improperly charged hundreds of defendants involved in the January 6 Capitol riot with obstruction. This decision has profound implications as it disrupts numerous cases against rioters who disrupted the certification of the 2020 presidential election. Additionally, the court addressed two other significant issues. It ruled that banning homeless encampments doesn't violate the Eighth Amendment, affirming local authority over homelessness policies, and it curtailed the power of federal government agencies to regulate broad aspects of American life. This latter decision overturned a 4-decade-old legal precedent that had been a target of conservative criticism. Chief Justice John G. Roberts Jr. announced that Monday, July 1st, will mark the final day of the term, a customary wrap-up time in late June for the court sessions. In response to the rulings, a spokesperson for the Biden campaign, Charles Lutvak, commented on behalf of the administration, emphasizing the importance of holding accountable those involved in violent insurrection. Lutvak criticized Donald Trump's stance, noting recent remarks defending the January 6th events and those who participated, stating, today's ruling doesn't change the fundamental truth that Donald Trump will always put himself over our democracy. Defense attorney stance. Lawyers representing defendants in January 6 cases expressed satisfaction with the Supreme Court's ruling, which narrowed the application of the felony charge previously unused outside of evidence tampering context. The Supreme Court has affirmed the common sense idea that a person obstructs justice only when they impair evidence, remarked Nicholas D. Smith, who argued against the government's position in the U.S. Court of Appeals for the D.C. Circuit. Until now, only 2 of the 18 federal judges who had ruled on this matter had sided with defendants in January 6 cases, with just one adopting Smith's argument that obstruction must involve evidence tampering. The Supreme Court's decision on Friday aligned with this interpretation. The Supreme Court got it right, noted Edward Ongvarsky, another attorney who has represented multiple January 6 participants. He criticized the Justice Department for, in his view, disregarding the fundamental principle that criminal statutes that carry 20 years in prison shouldn't be interpreted broadly to cover all kinds of innocent conduct. Oath Keepers. In high-profile cases targeting leaders of the far-right Oath Keepers and Proud Boys groups, significant legal developments have unfolded. Stuart Rhodes, founder of the Oath Keepers, and Enrique Tarrio, former chairman of the Proud Boys, along with their associates, were convicted in separate trials of obstructing an official proceeding. They also faced additional serious charges, such as seditious conspiracy, a law dating back to the Civil War era. Legal experts analyzing these complex cases suggest that despite recent Supreme Court rulings narrowing the application of obstruction charges, the overall impact on these defendants' sentences may be limited. Even if defendants seek to vacate obstruction convictions and request resentencing, the presence of other serious felony convictions could mitigate potential changes in prison terms. I think the U.S. Attorney's Office has been strategic in their approach, commented Nick Smith, a defense attorney representing Proud Boys leader Ethan Nordine. The implications of the Supreme Court ruling could soon be tested in the case of Thomas Caldwell, scheduled for sentencing on July 26th. The QAnon Shaman. Jacob Chansley, famously known as the QAnon Shaman, gained widespread attention as a prominent figure in the January 6th attack, appearing in the Capitol adorned in face paint and a distinctive horned hat. Chansley and a cohort of defendants opted to plead guilty to a single charge of obstructing an official proceeding. In return, prosecutors dismissed more serious charges like felony civil disorder and various misdemeanors. Initially sentenced to 41 months in prison, Chansley was granted early release. However, for defendants like Chansley, who solely admits to obstructing an official proceeding, there remains the possibility of seeking to overturn their sentences. Yet, this move could prompt the Justice Department to reinstate the dropped charges under the terms of their plea deals. It's not necessarily a get-out-of-jail-free card, cautioned defense attorney Richard Wilstadter, highlighting the intricate legal landscape and potential ramifications for defendants navigating plea agreements in the aftermath of January 6th. Donald Trump's next. Former President Trump stands as the most prominent defendant in a high-stakes legal battle led by Supreme Counsel Jack Smith in Washington. Trump faces 4 felony charges, including 2 counts of obstructing an official proceeding related to his efforts to overturn the 2020 presidential results. Legal experts suggest that despite recent Supreme Court rulings narrowing the scope of obstruction charges, prosecutors retain robust arguments to maintain the charges against Trump. They argue Trump was part of a conspiracy to obstruct the congressional certification of votes by allegedly introducing fraudulent ballots from purported fake electors. In Trump's case, that will be a real option, remarked Randall Eliason, a former federal prosecutor familiar with high-profile cases. Attorney General Merrick Garland underscored the significance of prosecuting those involved in the January 6th attack on democracy's foundational principle of peaceful presidential transitions. While noting the limited direct impact on the vast majority of defendants charged, Garland emphasized the Department of Justice's commitment to adhering to the Supreme Court's rulings. Reflecting on the broader implications, Jeffrey T. Green, attorney for defendant Joseph Fisher in the pivotal Supreme Court case, acknowledged the decision's potential ripple effects. Green expressed satisfaction that the court's ruling would restrict the application of the obstruction statute to its original intent of addressing evidence tampering. How the justices ruled. Chief Justice Robert penned in his opinion that while the government's interpretation of the obstruction statute might be technically permissible, the majority opted for a narrower reading. They resisted turning the statute into a catch-all solution for obstruction of justice, focusing instead on its original intent as an evidence-focused provision. Justice Amy Coney Barrett, in dissent joined by Justices Sonia Sotomayor and Elena Kagan, criticized the majority's approach as overly restrictive. Barrett argued that the court's interpretation required contorted contextual gymnastics to limit the statute's scope. She pointed out that Congress didn't foresee events like January 6 when drafting the obstruction law, which she described as broad in its potential applications. Justice Ketanji Brown Jackson, while aligning with the majority, emphasized in a separate opinion that Congress didn't intend to create a sweeping obstruction statute encompassing all forms of interference with official proceedings. She suggested that prosecutions of defendants like Joseph Fisher, who allegedly tampered with evidence related to the electoral vote certification, could still proceed under the revised interpretation. Former federal prosecutor Randall Eliason commented on the ruling, asserting that it reinforces the viability of obstruction charges against former President Trump. Eliason highlighted the court's example of submitting false evidence as pertinent to Trump's alleged involvement in a conspiracy involving fraudulent electors. Looking ahead, Eliason acknowledged logistical challenges for prosecutors handling resentencing and additional filings post-ruling, but predicted minimal impact on the broader landscape of January 6 prosecutions. He noted that defendants primarily convicted solely of obstruction, approximately 27 individuals, could be significantly affected.